Now, I'd like to take an opportunity to introduce today's presenter, Jennifer Damon. Jennifer has been with the AccuSource team for a little over 1 year and serves in the role of compliance manager. She does oversee both our compliance and quality assurance processes. Jennifer has 10 years experience within the background screening industry. She graduated from the University of Akron School of Law with a Juris Doctorate degree. Jennifer is a seasoned compliance professional and human resources professional and has served in roles for both direct employers and consumer reporting agencies. In her tenure, she has been responsible for interpretation of criminal and civil record summaries, management of quality control, and she managed the E-Verify program and audit processes for a billion-dollar facility services company. She has also had experience with government clearances and contract review. In her role with AccuSource, Jennifer is responsible regulatory compliance, including review and interpretation of federal, state, and local legislative and regulation changes, and also manages our NAPBS accreditation and vendor audit processes. Now, I want to go ahead and turn it over to the presenter, Jennifer.
Good morning and welcome to the webinar. We will be addressing a variety of topics today and we'll be answering questions at the end of the presentation. Please send any questions you may have and I will address as many of them as possible or will follow up through email if I do not have time to answer all questions during this time. During this webinar, we will first discuss where we have been so far in 2019, which have been very busy months for the background screening industry. We will also discuss what is on the table for the remainder of the year. More specifically, our review of the past 6 months will include an update on fair chance legislation, also known as Ban the Box, new salary history bans, updates in the world of privacy, including GDPR and California's version of GDPR, discussion of recent marijuana legislation. We will then discuss anticipated legislation and trends for the remainder of 2019, as well as best practice recommendations. Before I begin my presentation, please keep in mind the following. The content provided in this presentation is for informational purposes only. It should not be construed as legal advice or serve as specific guidance. AccuSource strongly encourages current and prospective clients to seek the advice of qualified counsel, preferably specializing in employment law, prior to engaging in any legal decisions involving drug and/or background screening policies or compliance concerns. Please also keep in mind that this is a general discussion. I will not be covering specific state laws and exemptions. For example, some employers may have exemptions to the general laws due to their industry or type of position. It is best to discuss your specific business needs with legal counsel to ensure you are compliant. Our discussion is also limited to criminal records. We will not be discussing credit reports, which are governed by federal law and are also restricted by certain state laws. First, we will discuss fair chance legislation, also known as Ban the Box. Fair chance laws have been and continue to be an important area of employment law in 2019. These laws prohibit employers from asking about criminal convictions before a certain point in the hiring process, generally before a conditional job offer is made or before an interview is conducted. For example, an employer in a ban the box jurisdiction typically cannot include questions about criminal convictions on the initial job application. In other words, they are banned from including a checkbox asking if the applicant has been convicted. As the name Fair Chance Law suggests, fair chance laws allow applicants with prior convictions to not only obtain an interview, but also advance to a certain stage in the hiring process before being asked about prior criminal history. Additionally, these laws may require that the background check process start later. In these jurisdictions, employers cannot use background checks to screen out potential applicants. About 3/4 of the US population lives in a jurisdiction that has banned the box, including states and more localized jurisdictions such as cities, municipalities, and counties. It spans a variety of employers, including public, private, or both. Several jurisdictions have enacted ban the box laws in 2019. Colorado has passed the Colorado Chance to Compete Act, which has a staggered effective date. Employers with 10 or more employees must come into compliance by September 1st, 2019, while employers of all other sizes have an effective date of September 1st, 2021. Under the Act, private employers cannot ask applicants about their criminal history on their applications and cannot require them to disclose it. More specifically, Colorado employers cannot state in job advertisements that those with criminal records cannot apply. They also cannot list similar restrictions or ask about criminal history on job applications. However, employers can ask about criminal records later in the hiring process. There are also exceptions to the law, especially where an applicant who has a certain type of criminal record and cannot perform certain jobs due to that record. Employers can also ask about records where its goal is to employ individuals who have a criminal history. Finally, an exception exists for employers who are required by law to perform criminal screening for specific positions. New Mexico took two noteworthy actions to help ex-offenders obtain employment. First, Senate Bill 96 amended the Criminal Offender Employment Act. This law became effective on June 14, 2019, so employers must come into compliance immediately if they've not already done so. The bill extends ban the box to private employers with 4 or more employees. It prohibits inquiries into an applicant's criminal history on employment applications. While employers are permitted to ask about criminal history, they must wait until after an interview. New Mexico also enacted the Criminal Record Expungement Act, which allows certain individuals to petition the court for expungement of criminal records. It becomes effective on January 1st, 2020. Generally, applicants with expunged records do not have to disclose them, and they also will not appear on background checks. If you have previously screened the applicant, keep in mind that that same record will no longer appear on future screens if they've been expunged. Westchester County in New York also enacted fair chance legislation. The Westchester Fair Chance to Work Act became effective on March 4, 2019. Private employers in this county cannot ask about a job applicant's criminal background during the preliminary stages of the application process. However, it does differ from New York City's ban the box law. In Westchester County, employers are allowed to ask about an applicant's criminal history after they have received an employment application. Employers are still required to conduct an assessment under Article 23A of New York's correction law, balancing the applicant's criminal history and the factors contained in Article 23A. As with similar ban the box laws, there is an exception for positions where background checks are required by law or where an employer cannot employ someone with a criminal history. Such positions include teachers and police officers. While it is generally best practice for employers not to ask applicants to disclose records that have been expunged or sealed, Vermont has taken it a step further and ensured this protection by making it law. Under the new H-460, which became effective on July 1st, 2019, employers are prohibited from asking about or requiring applicants to disclose arrests or convictions that have been sealed or expunged. If an applicant is asked whether he or she has any criminal records, he or she can answer no if that record has been sealed or expunged. Courts are also required to remove these records from their databases. West Virginia enacted a similar law. Effective on June 7, 2019, applicants are permitted to answer no if asked on the application whether they have a record if that record has been expunged. As with the New Mexico expungement law discussed earlier, you should keep these new laws in mind if you are rescreening an applicant or employee. If a record reported previously has been expunged or sealed, it will not appear on subsequent reports. While the trend has been for states and smaller jurisdictions to enact ban the box laws, that is not the case in Maryland. The state lawmakers had drafted HB 994, also known as the Criminal Record Screening Practices Ban the Box. The bill proposed to ban employers from requiring applicants to disclose criminal records at any time before the first in person interview. However, Governor Larry Hogan vetoed the bill, stating that employers have the right and often the need to know the criminal history of applicants they may hire. He is also concerned that the ban could lead to the loss of alternate candidates who have already moved on by the time an employer discovers the desired candidate has a disqualifying record. While the state will not move forward with this bill, employers in Maryland may still be bound by local fair chance laws. We will continue to watch Maryland to see if another ban the box bill passes or if the General Assembly overrides the governor's veto in early 2020. Finally, I would like to discuss legislation that's on the horizon. New Hampshire may enact a ban the box law if it passes Senate Bill 100. This potential law, which was recently passed by the New Hampshire House, includes a couple of restrictions. Employers would not be able to ask about criminal history on job applications. They also would not be allowed to conduct a criminal background check before an interview. While employers are restricted with what they can do before an interview, they are able to ask about criminal history at the interview. They can also conduct background checks after that interview. We will keep you posted about Senate Bill 100 and its status, as well as other proposed ban the box laws. As you can see, many jurisdictions have already enacted ban the box laws in some form, and others are joining each year, or at least considering whether to enact them. While you should always discuss employment law decisions with your legal counsel, we recommend reviewing legislation closely and consider removing all questions related to an applicant's criminal history. Doing so can lessen confusion and prevent accidental noncompliance, especially for multi-state employers. Another popular topic among jurisdictions is whether employers should ask about previous salary. Previously, various jurisdictions had banned employers from asking about salary histories, at least during some part of the hiring process. The goal of these bans is to address pay equity issues that are primarily due to gender. We will be discussing those jurisdictions which have either enacted bans or passed legislation in the first half of 2019. While you may not be based in a city or state that currently has salary history bans, keep in mind that you may have job applicants who do live in such jurisdictions. You should review with your legal counsel to determine if any salary history questions during the hiring process are appropriate for your specific situation. Numerous states have salary history bans as well as localities such as cities and counties. Alabama is the first of multiple jurisdictions we will discuss. The Clarks-Figures Equal Pay Act will become effective on September 1st, 2019. Not only does it prohibit pay discrimination based on sex or race, it also prohibits retaliation against an applicant who refuses to provide salary history information. Employers also cannot refuse to interview, hire, promote, or employ an applicant for employment if that applicant refuses to provide wage history. The law applies to both public and private employers, and there is no exception for small employers. While Alabama employers can still ask for salary information, this can be risky and may not be recommended in order to avoid potential issues. We will now move on to Colorado, which enacted the Equal Pay for Equal Work Act with an effective date of January 1st, 2021. Similar to Alabama, Colorado employers will not be allowed to seek the wage rate history of job applications. They also cannot discriminate or retaliate against a prospective employee for failing to disclose wage history. Maine passed an act regarding pay equality, which goes into effect on September 17, 2019. Maine employers cannot use, inquire about, or confirm an applicant's compensation history until after an offer of employment has been negotiated and made. Furthermore, the offer must include all terms of compensation. The Act does include exceptions. If an applicant voluntarily discloses his or her pay history, the employer is allowed to confirm it. The ban also does not apply to employers who are required to ask about wage history due to a federal or state law that requires disclosure or verification of that history. The state of New York has also enacted legislation. The Salary History Bill, which is effective January 6, 2020, applies to all employers. The employers cannot rely on wage history to determine whether to offer employment to an applicant or in deciding what salary to offer. Additionally, they cannot request or require, either orally or in writing, an applicant's or current employee's salary history as a condition to being interviewed or considered for an offer of employment, or as a condition of employment or promotion. Employers in New York also cannot refuse to interview, hire, or promote, or otherwise retaliate against an applicant or current employee based upon his or her salary history. They also cannot do that because an applicant or employee refused to provide his or her salary history, or because he or she filed a related complaint with the Department of Labor. While an employer is permitted to verify wage history with a current or former employer after a job offer with compensation has been made, it cannot do so beforehand. There are several exceptions to this ban. An applicant or employee can disclose the history voluntarily or provide it as support for a higher wage. Finally, an employer may request the information if required by federal or state law. Since April 2nd, 2019, state agencies in North Carolina cannot request pay history information from applicants. On the other hand, Washington's ban applies to all Washington employers regardless of size. Newly effective as of July 28, 2019, House Bill 1696 expands the protections under the Equal Pay and Opportunities Act. It generally prohibits employers from asking about an applicant's wage or salary history. It also bars employers from seeking the wage history directly from the applicant or indirectly through the applicant's employer. There are some exceptions. First, an employer is allowed to confirm an applicant's salary history where the applicant has voluntarily disclosed his or her salary history. Second, an employer may confirm the applicant's salary history after the employer has negotiated with the applicant and made an offer of employment, which includes compensation. Two cities in Ohio have passed salary history bans. Cincinnati's prohibited salary history inquiry and use ordinance, which is effective on March 13, 2020, applies to Cincinnati employers with 15 or more employees. Similarly, Toledo's ban also applies to employers with 15 or more employees. The ordinance was effective 1 year after it became law, so expected to be in place in 2020. Both the Cincinnati and Toledo laws have the same type of restrictions that we have previously discussed, including barring salary history inquiries and retaliation against applicants who refuse to disclose their prior salaries. Jackson, Mississippi enacted a law that became effective on June 13th of this year. Applicable only to the city of Jackson, applicants for employment with the city cannot inquire about salary history. Kansas City, Missouri's Fair Chance Law will go into effect on Halloween of this year. It applies to Kansas City employers with at least 6 employees. It specifies that employers are permitted to verify non-salary information and conduct a background check. The Montgomery County government in Maryland will be under a ban as of August 14th, while Suffolk County in New York is already subject to one that applies to employers and employment agencies within the county. Suffolk County's law restricts employers from conducting searches of even publicly available records when it comes to salary history. Finally, Richland County was required to remove salary history questions from applications, interviews, and employment screenings as of May 23rd. As you can see from the previous slides, ban the box laws are gaining in momentum. However, one such law faces legal struggles and could color the future of bans in other jurisdictions. Philadelphia, Pennsylvania previously enacted a ban on pay history inquiries. However, in 2018, a court found issue with the ban and granted a preliminary injunction temporarily blocking the part of the law that banned pay history inquiries. That court found that the ban violated the First Amendment's free speech clause. Since the injunction, the City of Philadelphia has asked the Third Circuit Court of Appeals to restore its previous ordinance. We'll be monitoring the Third Circuit's decision as it could impact salary history bans across the country. Privacy has been a huge concern in recent years, so much so that different countries and other jurisdictions are creating law that protects the privacy of their citizens. There are two privacy regulations that are especially causing concern among employers at this time. First, there is the General Data Protection Regulation, or GDPR, which was enacted in 2018. It applies to all organizations that process data belonging to European Union citizens, even organizations that are located outside of the EU. It provides EU citizens with more control over their personal data and strengthens already existing protections for that personal data. Because it applies across the countries of the EU, it allows for consistency among those nations and how data is handled and protected. If GDR applies to you and you're not already in compliance, you should do so immediately. First, determine whether you are considered a controller or processor of data. For example, in the screening industry, the background screening company is the processor of data, while the client is the controller of data. Both groups have responsibilities to protect data and can be held liable for the compromise of data and for failing to comply with GDPR. Because GDPR is a complex regulation, we cannot discuss it in detail today. However, we wanted to bring it to your attention since it is crucial to those who control or process the personal data of EU citizens. If you fall into that category, here are some tips that can help bring you into compliance. First, focus on the data itself by defining it and auditing it. Make sure you have a legal basis for processing that data. Be prepared to justify why you can conduct criminal background checks. Second, get your documentation in order, including privacy notices, employment agreements, and policies. Third, conduct assessments to determine your risk and create a plan in the event of a data breach. Finally, prepare to demonstrate your compliance with GDPR. Designate a data protection officer if required, pay any fees, and create and maintain records. Even if you do not screen any European Union citizens, you may still be affected by a similar data privacy law. In 2018, California enacted the California Consumer Privacy Act of 2018. It has been referred to as the US GDPR because of its similarities to GDPR. As with GDPR, it seeks to protect the personal data of California citizens, especially those who are 16 or younger. Under the CCPA, California residents, including minors, have the right to know if their personal data is being collected. They also have the right to know to whom their information is sold or shared and can object to the sale of their data and have it deleted. This is known as the right to be forgotten. While the CCPA is complicated, there are several major steps businesses must take to be compliant. They must provide specific public disclosures, as well as provide consumers with a description of their rights under the CCPA. The law also requires certain updates to a company's privacy policy, including reviewing and updating the policy annually. Businesses must take several steps to comply with the CCPA. First, the business should map its data, which will help it determine the types of personal data it has, where and how it is held, evaluate the handling and protection of data, and create policies and procedures to ensure the protection of that data. The business should also create a breach response plan. It must provide specific public disclosures and also provide to consumers a description of their rights under the CCPA. It must also publish opt-out rights and provide the ability for a consumer to opt out of the sale of his or her data. The business will need to update its privacy policy to bring it into compliance with CCPA and review it regularly. If using third-party vendors to process data, the business will need to revise the agreements with those parties to ensure CCPA compliance. Creating internal processes to handle consumer requests is also critical. How will employee data be treated under the CCPA? Employee data includes the personal information belonging to employees, contractors, and job applicants. Originally, a bill had surfaced which sought to exclude employee data from the scope of CCPA. However, the Senate very recently amended the bill. With this change, employers and those who handle employee data will now be subject to CCPA when it comes to employee data. AB 25 does include a one-year reprieve for employee data, becoming effective on January 1st, 2021. However, it is a limited extension, applying only when an employer uses the data in the scope of its employment relationship for employment purposes. Any other use is subject to compliance by the original 2020 deadline. No matter what, employers must still notify employees, contractors, and job applicants of the personal information that they collect and how they use it. AB 25 is not law yet. AccuSource will monitor and provide updates when they are available. Another issue currently faced by many employers is how to approach drug testing due to the increase of jurisdictions with marijuana use laws. Because there is no standard rule on whether employers can test for marijuana, and because marijuana remains illegal on the federal level, employers can be unsure on how to handle employees who smoke weed. First, we will review the legislation that has passed or been amended up to this point in 2019. Hawaii, New York, and North Dakota have decriminalized marijuana, while Illinois took it further and legalized the recreational use of marijuana. Several states have provided additional protections for employees who use marijuana, including New Jersey, New Mexico, and Rhode Island. New York City has banned pre-employment drug testing for marijuana, and Nevada has enacted restrictions for employers who test for marijuana. The question is how these newly enacted laws will affect employers in those jurisdictions when it comes to their drug policies. In general, the answer is yes. Employers can still drug test in many of the jurisdictions that have legalized marijuana in some way, but it is not black and white answer across all jurisdictions, as we will see with New York City. In addition to whether an employer can drug test for marijuana, an employer must also consider how it can test for current usage of marijuana. We will start by discussing the decriminalization of marijuana in several jurisdictions. While decriminalizing marijuana does not make its use for medical or recreational purposes legal, it is a step towards legalization. Hawaii had several marijuana-related bills to consider. While the governor did not legalize marijuana use, he did decriminalize it when he failed to veto the bill. Small-scale marijuana possession had previously been punished with jail time. However, after decriminalization, a Hawaiian who possesses 3 grams or less of marijuana will instead be charged a $130 fine. New York State also decriminalized marijuana, reducing penalties for low-level possession, which is now a violation rather than a criminal offense. In addition, the state will develop a program that provides information to the public about how to expunge marijuana convictions. North Dakota also decriminalized marijuana, passing HB 1050 with an effective date of August 1st, 2019, so just a couple days from now. The law reclassifies the possession of up to half an ounce of marijuana by someone who is at least 21 years old to an infraction. There is no jail time for this class of possession, and the possessor faces up to a $1,000 fine. While these laws decriminalize marijuana, they do not require employers in Hawaii, New York, or North Dakota to accommodate its use. Illinois has become the most recent state to legalize the recreational use of marijuana. In addition to legalizing marijuana, the Cannabis Regulation and Tax Act decriminalizes recreational use. The new law becomes effective on January 1st, 2020. The Act explicitly states that employers are allowed to maintain drug-free workplaces, can drug test, and can discipline or terminate employees who violate employment policies. In addition, employers are not required to accommodate recreational marijuana to the point of violating federal law or placing government contracts at risk. However, the Act does not expressly state whether employers can prohibit the use of marijuana outside the workplace. As we approach 2020, Illinois will likely provide further guidance. Several jurisdictions have expanded protections for employees who use marijuana. New Jersey extended workplace protections to employees under the Jake Honig Compassionate Use Medical Cannabis Act, which took effect on July 2nd. Employers cannot take adverse action against an applicant or employee based solely on his or her status as a registered qualifying patient. Additionally, employers must allow him or her an opportunity to explain a positive marijuana drug test. If the applicant or employee prefers, the employer must provide the ability to have the sample retested at his or her own cost. While an applicant or employee may provide a medical explanation for a positive result, the employer is not required to accept it. Employers are also not required to disregard positive marijuana results or permit the use or possession of marijuana during work hours. Finally, employers are not required to take any action that could violate federal law or cause it to lose licensing or a federal contract. New Mexico has also provided some protections for applicants and employees when it amended its medical marijuana law. As of April 4th, 2019, employers cannot take adverse action against applicants or employees for conduct that is permitted under the medical marijuana statute. However, there are some exceptions. An employer is not required to risk its monetary or licensing benefits under federal law. It can also take action against an employee who uses or is impaired by medical marijuana while at work. Finally, safety-sensitive positions are exempted from this law. The final state to expand protections is Rhode Island, which enacted the Hemp Growth Act. Rhode Island employers cannot refuse to employ or otherwise penalize an applicant or employee solely for his or her status as a medical marijuana cardholder. Similar to other laws we have discussed, Rhode Island has provided exceptions. Employees cannot use or possess marijuana in their workplace or work under the influence. They also cannot operate vehicles, equipment, or firearms while under the influence. The employer is not required to permit behavior that violates the terms of a collective bargaining agreement and risk its monetary or licensing benefits. While some jurisdictions are providing more protection for applicants and employees, New York City is going further. Effective on May 10th, 2020, Intro 1445A prohibits New York City employers from requiring applicants, as a condition of employment, to submit to a test for the presence of THC or marijuana. In essence, this bars pre-employment drug testing for marijuana. However, there are exceptions. Employers are permitted to test for marijuana for certain positions, generally those involving safety, driving, and the care of children or other vulnerable persons. Those who occupy positions paid for by federal grants or who receive financial benefits where drug testing is required can also be tested. If a collective bargaining agreement addresses pre employment drug testing, an employer may also be allowed to test for marijuana before hire. Note that this law only applies to pre employment drug testing. It does not appear to cover drug testing for current employees, including post accident, random, or reasonable suspicion. Nevada has also provided protection for applicants by passing Assembly Bill 132, which is effective on January 1st, 2020. Nevada is the first state to protect applicants with positive marijuana drug test results. The law prohibits employers from refusing to hire job applicants who test positive for marijuana. There are some exceptions, including firefighter and EMT positions, jobs requiring the operation of a motor vehicle, if federal or state law require testing, and positions that employers determine could adversely affect the safety of others. Another portion of the law is interesting. If an employer requires a new employee to take a drug test within the first 30 days of employment, and that employee tests positive for marijuana, the employee can submit to a new drug test in order to rebut the results of the original test. The employee must pay for this new test, but the employer is required to accept and consider the new results. Nevada also passed the Nevada Second Chance Act, effective as of July 1st. It permits a person to petition the court to seal criminal records tied to any offense that has been decriminalized, including low-level marijuana convictions. In addition to new marijuana legislation that is passed, the courts and jurisdictions with legalized marijuana have been busy clarifying the rights of marijuana users. In Whitmire v. Walmart, an Arizona court held that high levels of marijuana in a drug test was insufficient to show an employee was impaired while at work. A New Jersey court discussed reasonable accommodation in Wild v. Carriage Funeral Holdings, finding that employers may also be required to reasonably accommodate employees who use medical cannabis. As additional courts provide clarification on marijuana laws, we will provide updates. With new marijuana legislation comes questions on testing for usage of marijuana, which causes another issue for employers. Marijuana testing differs from alcohol testing. An alcohol test can show if a person is currently intoxicated by alcohol. However, it is not possible to test to determine if a person is currently under the influence of marijuana. A positive marijuana test could show marijuana that was ingested days or weeks ago, so it's not a good indicator of whether someone is intoxicated due to marijuana use in that specific moment. Because there is no accurate test, an applicant or employee can use marijuana legally but still have a positive drug test result. While there is no clear answer as to how employers should approach this issue, it is recommended to treat applicants and employees in the same way, taking into consideration any applicable state or local laws relating to marijuana use. Overall, states' marijuana legalization laws do support employers who want to test for marijuana use and take action against applicants and employees who use marijuana, even if that use is legal. However, it appears that the tide may be turning in support of employees. "2019 is more than halfway over. What can we expect for the remainder of the year? Generally, we can expect to see more of the same. Ban the box legislation keeps gaining steam, and we will likely see more jurisdictions joining the movement or expanding already existing laws. The number of salary history bans has been increasing as jurisdictions seek to equalize the salary field. We will likely see more jurisdictions addressing the pay disparity with their own laws. Privacy will continue to be an important focal point for the remainder of 2019 and beyond. Other states, and even the federal government, may look to GDPR and California's privacy laws and enact their own laws. Marijuana is such a hot and critical topic that AccuSource is dedicating a webinar to it in October. As more jurisdictions legalize marijuana, either medical or recreational, we hope that the courts will continue to provide guidance as to the rights of employers. In the near future, we may even see a federal marijuana law that would legalize marijuana on a federal level. We also hope to receive guidance from Nevada and New York City regarding pre-employment marijuana testing and how employers should tailor their drug screening programs. AccuSource will keep you posted of any industry trends and hot topics as we learn of them. AccuSource is happy to recommend some best practices. First, thoroughly review your background and drug screening procedures, as well as hiring practices, to ensure that you are compliant with any new laws. Review your employment applications and hiring practices to make sure that you're not seeking information about criminal history. While you may not be based in a ban-the-box jurisdiction, you should be aware that many jurisdictions do have restrictions. Similarly, be aware of any salary history bans in your state or locality. If there are any restrictions, you should eliminate salary questions during the hiring process, document if the applicant self-discloses his or her salary history so that you have a record of it, and include pay rates and job descriptions as required. Watch new privacy laws closely and determine if you need to be compliant with any that are already in existence, such as GDPR or California's privacy law. Finally, remember to keep a close eye on the legalization of marijuana, especially court decisions regarding whether an employer can still drug test for marijuana and how such decisions affect your workplace. We have reached the end of this presentation, and I will now answer questions that we received.
If you have not had a chance to ask a question via our chat box, please feel free to do so now.
Thanks, Dustin. The first question is, I am an employer with the employees in different states. How do I ensure compliance with ban-the-box laws and salary history bans?
Thank you. If you have employees in a number of different states, you might want to consider removing criminal history questions and checkboxes from your application completely. You might also want to remove any questions regarding salary history. While it's possible to have different versions of the application to meet the different ban-the-box and salary history requirements, it would be easier to maintain one uniform application. It's not worth the risk of providing a specific application based on someone's location. You could risk giving them information they really should not be seeing. So it would be easier to maintain one uniform application. You should also review your hiring process to determine if it is compliant with the various laws and tailor it if necessary.
Perfect. The next question, how can I, as an employer, protect my workplace without violating the rights of legal marijuana users?
That's a really good question, especially considering all the new legislation and court decisions that we were just talking about. While in general, the laws and decisions have been leaning towards employees, an employee still typically cannot use marijuana on his or her employer's property. If you're concerned about employees being under the influence while at work, you can set up guidelines for managers to follow to determine whether an employee is under the influence of marijuana. Remember, though, that there's not really an accurate test for marijuana intoxication, so you'd really have to rely on physical cues that an employee is under the influence, and you should definitely provide a summary of those physical cues to your management who might be seeing it. While you might be able to take action against an employee who is under the influence at work, you should review any laws that apply to you to see if you have rights beyond that. The key is to be uniform and to have solid policies that clearly lay out your company's treatment of marijuana. We will address this topic in more detail during our October webinar, which is going to focus solely on marijuana.
Perfect. This is actually a two-part question. Can we drug test for marijuana in Nevada for current employees?
So right now in Nevada, it appears that it applies to pre-employment testing, but I'm sure that as time goes on, that we'll get more clarification on that. This is a pretty new law that came into effect, so my hope is that we're going to get a lot more clarification, so that way by the time it does go into effect, we have a lot more clarification on it.
Okay, and the second part to that question was, can we have a drug-free workplace that has marijuana included for Nevada?
That is a very good question. Um, from what I've seen, a lot of courts have said in general that you can still have a drug-free workplace, even if even if there are legalization rules in place. However, because Nevada's law is so new, I don't think that they provided guidance for that. So hopefully I'll be able to cover it in the October webinar.
Awesome. It seems that law and courts are siding with applicants and employees who use marijuana. Should we remove marijuana from our drug testing panel?
Well, unless you have applicants or employees located in a place that specifically prohibited testing for marijuana, it's really not necessary to remove it from your panel. However, you can consider following New York City's trend and remove it from your initial pre-employment testing panel. You can keep it in the panel for other types of testing, such as post-accident and randoms. If you are impacted by New York City and have employees elsewhere, you might want to consider removing marijuana from pre-employment testing across the board. Not only would it simplify your process, it's going to create a more uniform drug testing policy among all of your employees. As always, it's best to speak to your in-house or outside counsel who specializes in this area to review your specific situation and the laws and court decisions that may impact your company.
All right. Can you state on an application, would you be able to pass a federal background check with a yes or no checkbox?
It really depends on the jurisdiction. I had worked for a national company, and even though back then there were far fewer beyond the box laws than there are now, we had removed it across the board just to simplify things and not take that risk. I mean, yeah, it's possible that you could have someone who can't pass the federal background check, but is it worth the risk in a potential class action lawsuit to include that question for the possibly few applicants who can't? If you're going to discuss it at any point, I'd probably do it after the interview process. But again, you have to really watch the laws because they're very specific as to when you can ask questions like that.
All right. I understand that for California, the employer has an obligation to disclose pay range for an advertised role after the first interview, if asked by the candidate. Do phone interviews count as the first interview?
So I have not reviewed that specifically because I'm not involved with the hiring process and pay process for AccuSource and have not been for other companies. But I would imagine that there's probably some guidance on that. I know generally phone interviews are fine as long as it's more of an official interview rather than just a quick question to see if the person's interested. So I would probably ask your local legal counsel who is more versed in that type of employment law.
All right. What if our company requires a drug test? If the state law like New York prohibits it, how should we address it?
Um, Well, if you want to be nice to the company, you could always bring it up to them and say, "Hey, so I don't think I have to take this drug test per this law, um, but I, it's really up to companies to be very, very careful when it comes to that. If you are asked to take a drug test in a jurisdiction where you're not required to, I would just bring it up to the recruiter and go from there."
All right. With marijuana being legal in California, how does that reconcile with an employer policy that is still termed to the use of it as zero tolerance?
So this is kind of a tricky area, and even the courts have recognized that it's a tricky area because you can't test to see if someone is actually intoxicated in the moment by marijuana like you can with alcohol. It becomes tricky because someone could use marijuana legally over the weekend and come into work and be tested and show positive, even though they haven't partaken in marijuana that day. Um, so, while it is possible to have programs that allow for both a zero tolerance and to allow your employees to use the marijuana legally, the courts are just going to have to discuss that and hopefully resolve this gray area that's really in effect across the country.
All right. Is there any discussions to change the current CDL licensing laws to allow for exclusions of marijuana testing?
Um, if it's under the DOT and it's more of a federal regulation, I seriously doubt it, especially since marijuana is not legalized on the federal level. However, I literally just saw this morning that one of the senators is co-chairing a bill to legalize marijuana on the federal level. So first we'd have to see where that goes. And even so, I doubt that they'll allow marijuana use for like federally mandated DOT positions and CDL licenses for the states. It all depends on whether or not the regulations are updated. So I'm guessing no, but we'll have to see what happens.
All right, and we're almost at the end of our time, Jennifer, so this will be the final live question. Again, attendees, if you're entering a question into the chat box and we did not have an opportunity to address it live, our team will follow up with you directly with you post-webinar to provide an answer. So the last question is, I work for a company that may be impacted by the CCPA because we have employees in California. What do you recommend?
Well, it all depends on what you do with the data that you obtain from those who live in California. If you only deal with the personal data of employees in California, then you likely will have a lesser burden than those who sell the data of California residents. Employee data is up in the air right now, unfortunately. Originally, it would have been excluded from the CCPA, but the California Senate disagreed and stated that the CCPA will apply to employee data in some ways. Because it's still up in the air, employee data will not be impacted until 2021, but you should review the CCPA to see what you may need to do before the original January 2020 date. As we learn more, AccuSource will definitely keep you posted on this topic.
All right. Thank you, Jennifer, for facilitating this informative webinar. And special thanks to our attendees. We appreciate every one of you that has joined us today. Please also feel free to visit the resource section of our AccuSource website at www.accusource-online.com. Here you will find our full webinar, as well as a library with other valuable compliance and educational resources. If you do have any additional questions or need further assistance, please contact us at marketing@accusource-online.com. On behalf of the AccuSource team, we want to wish you all an enjoyable day. Thank you.